Hello my friends, I Forum Patel from Melcher School of Law would like to warmly welcome you all to the third session on the Standing Orders Act under Labour Law 1. Now, in the previous sections, we did talk about the Standing Orders Act, Model Standing Order and Standing Orders definitions, the powers of the certifying officer, appeal section, and the application for the registration of the standing orders and certain aspect to certain questions. Now, in this session, we shall be discussing about the offences and penalties and also of the act of the misconduct. So friends, let's get started by the understanding of acts of the misconducts. In the draft of the standing orders, my friends, it is very important to define that on what basis the person may be prosecuted for the act of the misconduct. Every model standing order should be having a list of those kind of activities. Now, as you can see on the screen, there are certain acts of the misconduct that has been given. The first one is going on the illegal strike. Second one, willful slowing down the performance of the work. Third one is theft, fraud, dishonesty in connection with the employer's business or property or theft of the property of another workman within the premises of the establishment. Next one is taking or giving bribes. The next one is habitual absence without leave or for more than 10 consequential days. Then collection without the permission of the manager or of any money within the premises of the establishment except as sanctioned by the law for the law time being in force. That means, my friends, that these are certain activities. A person cannot go on the illegal strike. A person has to give reasoning if the person is remaining absent for more than 10 days. The person cannot commit the act of the theft or fraud or from the employers also and from the colleagues also. They cannot take or give the bribes. Then they are not allowed to act in any way which willfully slows down the performance of the act in that industry. These are certain acts of the misconduct. This is not the end of the list, my friends. There are certain other acts of the misconduct. Let's have a look. The next acts of the misconduct, my friends, as you can see on the screen, is that engaging in trade within the premises of the establishment. Then drunkenness or riotness or disorderly or indecently behavior on the premises of the establishment, habitual neglect or habitual attitude of the neglect towards the work, habitual breach of any rules of the instructions that has been given by the authority, willful damage to the work in the process of any property or of the establishment, holding meeting inside the premises of the establishment without previous permissions, without previous due permissions of the manager or except in accordance with the provisions of any law for that time being in force, disclosing or any unauthorized person any other information which is confidential in its own nature, smoking and spitting on the premises of the establishment where it is prohibited by the employer, and unauthorized possession of any lethal weapon in the establishment. If, my friend, any employee is doing any such acts of the misconduct, that person would be held liable to be prosecuted for the offences and penalties which has been laid down under the section 13 of this act. That means, my friend, that the standing orders rules or it also regulates the act which are allowed in the premises of the establishment of the industry and which are not allowed, which can be considered as a misconduct if you are conducting or if you are acting in the same way in the premises, my friends. Let's have a look at the penalties section or at the offences section of 13 of the act. Under this act, an employer fails to submit the draft standing order as required by section 3 or who modified the standing orders otherwise within section 10 shall be punishable with fine which may extend to 5,000 rupees in case of the continuation offence with a furtherance of 200 rupees every day after the first during with the offence continued. The employer who does not act in contravention to the standing order finally certified under this act for the industrial establishment shall be punishable with a fine which may be extended to 100 rupees in the case of the continuous offence with further fine of 25 rupees every day. No No prosecution for any offence which is punishable under this section 13 shall be instituted except with the previous sanction of the appropriate government. It can be tried only in the court of the presiding magistrate or the secondary class of the magistrate. So friends, this was all about the act of the misconduct and the penalties which has to be laid down. If any person is held liable for the misconduct, what is the procedure for the disciplinary action against that person? The disciplinary inquiry is carried out by the disciplinary committee of the respective establishment in relation to the matters of the misconduct of the employees. Such committee generally should comprise of the workers' representatives such as the members of the trade union as specified under Rule 14 subclause 4(b)(a) of the Industrial Employment Standing Orders rules, employers' representatives such as head of the department where the workman was employed, and the third one an independent officer, that is an inquiry officer. An internal hearing to ascertain the guilty of the workman of the alleged misconduct is conducted by the administrative officer. Domestic inquiry is mandatory in order to dismiss the employer. However, it is not of course necessary for suspension if by the way of the punishment. The due process of the complaint has to be followed. Now, what is this due process? There are certain steps which has been given under the law. First of all, the complaint needs to be made. Then after, the primary inquiry is to be done. Then filing of the charge sheet is to be done. Then appointment of the inquiry officer is to be made. Then suspension of the pending inquiry is to be done. Then notice of the inquiry has to be given to the party to whom the inquiry is there upon. Then employees hearing is done. Then examination of the witnesses followed by the report of the committee has to be prepared. Now, when this disciplinary inquiry, my friends, is being carried out, there are certain principles that they have to keep in mind. They are the principles of the natural justice. Whenever any employee commits any misconduct, in order to decide the fate of their employment, they have to fulfill the requirements. Now, these requirements are of certain rules, which are the rules of the, or rather the principles of the natural justice, the right to make the representation, etc., etc. That means the management of the industrial establishment must satisfy the principles of the natural justice while maintaining a neutral attitude towards the workmen. You cannot keep that in mind that the workman must be at fault and so you have to just throw him out of the establishment. You have to be very neutral when you are deciding, when you are hearing it out. You have to gather the information, you have to prosecute the examination, you have to witness, you have to prosecute the witness, you have to examine the witness, you have to give them the chance to prove themselves. The charges cannot be levied upon that person until and unless it is proven one. The principle of the natural justice in this way must be followed when the disciplinary procedures under the Standing Order Act has to be fulfilled. The next rule is that the right to make the representations. The delinquent workman should have the right to represent against the finding recovered in the inquiry report to the disciplinary authority, my friends. This right has been laid down in the case of Union of India versus Mohammad Ramzan Khan in 1991. This means that it is everybody's right to make the representation for their case and nobody in the industrial establishment also can take this right away from that individual. When we were talking about the procedure for the disciplinary committee, the first step was having the preliminary committee. In the landmark judgment of Amulya Ratna Mukherjee versus Eastern Railway, my friends, it was observed by the High Court of the Calcutta that before making a charge, the authorities are entitled to have the preliminary investigation or fact-finding inquiry which is known, so that they receive whenever they receive the complaint from the employer. This is not a consideration of the formal inquiry, but it is just a rule that has to be observed by every authority. After that, the charge sheet may be filed. It is essential, it should contain essentials or particulars of the details of the misconduct, specific charges which are being laid down according to the standing orders against the workmen. In Sir Enamel and Stamping Works Private Limited versus their workmen in 1963, the Honorable Supreme Court, in attempt to lay down the procedure for conducting the inquiry for industrial adjudication, provided that an inquiry cannot be said to have properly been held unless there are certain rules that has been followed by them. There are 4 rules which has been laid down by the Honorable Court in this case. The first was that the workmen proceeded against must be informed clearly about the charges. The witnesses must be examined in the presence of the workmen. The workmen must be given a fair opportunity to cross-examine the witnesses also, and an inquiry officer must record his findings with the reasonings in his reports. After the charge sheet has been served on the accused workman, my friends, he may be sent for the explanations. That means he is allowed to give the explanations in the manner admitting the charges and pleading for mercy, or denying the charges in totality, or requesting for more time for submission of the explanation from his side. During this time, the whole supply of the relevant materials, examination of the witnesses, following of course general rules for the examination given by the court, has to be done. It was observed by the court for the examination of the witnesses in Tata Engineering and Locomotive Company Limited versus S.C. Prasad case that if the allegations mentioned in the charge sheet are denied by the workmen in domestic inquiry proceedings, the onus of providing those allegations will be upon the shoulder of the management to be proven. Now this was held of course for the examination rules. The witnesses called by the management must be allowed to be cross-examined by the person who has been alleged with the charges of the due process. The workman must also be given a reasonable opportunity to examine himself and also to further add the piece of evidence in his support if it is needed. The report of the inquiry officer has to be submitted once the employer and the workmen have been heard. The officer has to prepare a full-fledged report along with its findings, along with its submissions and the reasoning. The duty of the inquiry committee would stand still until and unless the report has been submitted. Now let's keep in mind, my friends, that any act or omission of an employee, whether amounts to the misconduct or not, is to be governed in accordance with the provided list of the industrial establishment rules. Although no statute or law specifically lays down the procedure of this conduct, the disciplinary inquiry, the various judgments of the industrial tribunals have laid down the basic idea of this procedure. That was the reason the procedure has not been prescribed in the act, my friends. It has been understood by the practice so far by everybody and by the courts also. So this was all about the offences, penalties, misconduct, and also about the departmental inquiries, their proceedings, and certain essential criteria along with important case laws. So friends, this was all about the Standing Orders Act under the Labour Law 1. So let's put an end to this session. We will be discussing about the importance of having this Standing Orders Act in the next session very briefly while having an overview of this act. Till then, stay tuned and keep learning. Thank you.